over to the judges.
Welcome, students. Congratulations on making it to the national finals. You are to be rewarded for having done an excellent job in the first semester. I am Edward Volpe. I'm an attorney from Denver, Colorado, and my colleagues are.
I'm Caitlin Johnston. I am an attorney in New York City, and I am also a We the People alum. So congratulations on being here, and I look forward to the discussion.
I'm Ed Murphy. I'm a Superior Court judge in Tacoma, Washington. And again, congratulations for being in the national finals.
And if the students would introduce themselves in the order in which they will be presenting, please.
Hi, my name is Rain Watt, and I'm a junior.
Hi, my name is Jackson Sharp, and I'm a junior.
My name is Ruby Stevens, and I'm a junior.
My name is Scarlett Prather, and I'm a junior.
My name is Jude Wolf, and I'm a junior. And our teachers are Mandy Hostetter and Matthew Fulford.
All right. Who is the student after Ruby?
Scarlett Prather.
All right. Thank you for that. All right. The question we have for you today, I presume you are aware, is question 1, and I will read it to you. A result of the decision in Wisconsin v. Yoder is that any parent or guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs. Do you agree or disagree with this result of this decision? Why or why not? What words, if any, are found in the United States Constitution or in state constitutions that protect the right to an education? How have courts balanced the religious beliefs with other rights? You may begin.
Perhaps no aspects of American life give rise to as much controversy as religion and public education, 2 areas where people express their most deeply held values, ideals, and identities. The Supreme Court has produced many confusing and contradictory opinions when reviewing questions of education, religion, or both together. Wisconsin v. Yoder 1971 examined many layers of competing interests: the fundamental right of parents to raise their children as they see fit, Pierce v. Society of Sisters 1925, the state's interest in fostering effective citizens, and religious considerations. The narrow decision attempted to preserve as many of these interests as possible. The quote from the question misstates Yoder's holding by claiming people may opt out of lessons they find objectionable, which the Supreme Court never considered.
San Antonio School District v. Rodriguez 1973 held that education is not a constitutional right, as there are no words in the U.S. Constitution that enumerate it. Educational advocates have since been working to overcome this ruling. Just last year in Gary B. v. Whitmore, the Sixth Circuit recognized that the Constitution does provide a fundamental right to a basic education under the 14th Amendment. Despite the lack of a federal right to education, the 14th Amendment ensures that state guarantees of education are enforceable in federal court, such as Plyler v. Doe, 1983, which rules that education may not be denied on the basis of citizenship. Yet most state constitutions are surprisingly vague about what exactly is guaranteed, such as Colorado's right to a thorough and uniform system of free public schools.
Constitutional rights in school remain controversial. Tinker v. Des Moines 1968 held that students do not abandon their constitutional rights at the schoolhouse gate, yet narrowed students' rights of expression while in school. Morse v. Frederick 2007 sided with school officials to suspend a student for displaying a banner urging bong hits for Jesus at a school event. Mahanoy Area School District v. BL, a current case examining whether a school may expel a student for off-campus speech posted on social media, may expand, curtail, or overrule Tinker. Inconsistency seems to be a fundamental tenet of these cases. Hazel v. Kohlmeyer 1988 held that the school newspaper is not a forum for public expression. Adjudication of religious rights has also led to inconsistent and often contradictory Supreme Court rulings. Employment Division v. Smith 1990 held that neutral laws of general applicability trump free exercise rights. Church of Lukumi Bablu Ia v. Hialeah 1993 applied Smith to strike down a law targeting a specific religion.
But Masterpiece Cake Shop v. Colorado Civil Rights Commission 2018 and Burwell v. Hobby Lobby 2014 both ruled the other way, holding the free exercise rights trump laws of general applicability, leaving the state of the law in a state of confusion. American Legion v. American Humanist Society 2018 adds to the ambivalence. Holding a state-owned 40-foot cross does not violate the Establishment Clause, and Yoder is hardly the first case to address religion in schools, a fraught combination. Engel v. Vitale, 1962, prohibits organized prayers in public schools, even if it is not required and not tied to a particular religion.
Likewise, Abington School District for Shemp, 1963, held that public schools cannot sponsor Bible readings and prayer. And Epperson v. Arkansas, 1968, held that public schools could not ban the subject of evolution, both under the Establishment Clause. Like the Supreme Court, our panel is split on whether Yoder was decided correctly. Some of us believe that the state's interest in a formal education is paramount and that individual beliefs should not be permitted to exempt students from this benefit. The rest of the panel believes that the freedom of thought and religion must allow leeway to provide educational alternatives to the state-determined curriculum. But we all agree that it is unlikely that these issues will be finally decided anytime soon. We are now open for questions.
Has the Supreme Court given us any guidance as to what tests or standards will be applied to any law that affects religious beliefs?
Yes, so the precedent set by Employment Division v. Smith finds that any laws of general applicability aren't subject to strict scrutiny. And also when dealing with federal regulation, that would imply RFRA, which the Supreme Court can grant injunctive relief.
And as held in Lee v. Weissman, 1992, the principle that the government may accommodate the free exercise of religion must not supersede the fundamental limitations imposed by the Establishment Clause. And as the court's makeup has shifted to a more conservative and religious makeup, we are seeing them lose sight of that tenet.
And in addition, as we saw in Sherbert v. Verner, 1963, they set the precedent that the court must first inquire whether religious beliefs are sincere before they receive the First Amendment protections.
Although, just to clarify, we don't believe that the court is actively using that Sherbert precedent anymore.
So let's move to the individuals in cases like Yoder. How should a court weigh a child's rights against the religious beliefs of their parents, and consider a hypothetical with me of a religious sect that compels young girls to marry and bear children before they've reached the age of majority? How would you handle something like that? How should the courts deal with that?
This was a primary reason why the panel did disagree initially over the result of Yoder, because some of us believed that the children's right to an education and their right to participate in society was definitely implicated.
However, it's important to point out that Yoder was able to effectively prove that once engaged in high school, most Amish children typically would not pursue Amish lives, and they were able to prove that high school represented a certain worldliness that came into direct contradiction of the children's way of life as well as the parents.
And to contrast that, in Pierce v. Society of Sisters, 1925, the court observed that the government cannot unreasonably interfere with the liberty of parents and guardians to direct the upbringing and education of their children. And even Thomas Jefferson, who was a huge supporter of education, was reluctant to force instruction of children in opposition of the will of the parents.
And to, just answer your scenario question, we'd find that there would definitely be a compelling state interest to prevent the marrying off of young girls.
Is it lawful for the state or a school to require that students be vaccinated against the coronavirus, even against a parent's religious beliefs, before the child's allowed to return back to school?
Currently, all 50 states have legislation requiring specific vaccines for students, and 45 of these states allow religious exemptions, with 15 of these states allowing philosophical exemptions based on a person's moral objections. And Colorado allows for both of these.
And in Jacobson v. Massachusetts, 1905, the Supreme Court upheld the authority of states to uphold compulsory vaccination laws.
And if there was a current case, we could definitely expect the court to rule in favor of religious rights, especially following Tandem v. Newsom 21, where the court ruled that a law that seemed generally applicable was still targeting religion under employment division.
And we are already seeing colleges starting to require COVID vaccines, with the first large public university being Rutgers University. And these cases are just proving the extreme inconsistencies of the court in balancing interests of public good and safety versus First Amendment interests. But under current precedent, yes, schools can compel students to get a vaccine.
Very good. Do student religious groups have access to school facilities for meetings during non-instructional hours?
So the Supreme Court ruled that having a Bible study was unconstitutional and was establishing religion, even if the students are taking that initiative on themselves. And also even having a moment of silence for prayer or meditation would also be establishing religion. So we're going to say no.
And of course, that is only applied to public schools. Private schools obviously have different rules, and there are lots of religious private schools.
So you mentioned that the quote misstates the court's decision. Tell me more about the opt-out, and do you think students should be allowed to drop out of school when they reach 16?
So yes, the court's actions in Wisconsin v. Yoder was pretty synonymous with injunctive relief. They didn't create any precedent because it was a very rare occurrence where a student's way of life or a family's way of life came into direct conflict with high school. And that's the reason why the court ruled in favor of Yoder. But it doesn't set precedent for families opting out.
And our panel would like to point out that Yoder states that children can drop out of school at the age of 14, which is only 2 years previous to the current legal age, which is 16. Say if it had been significantly earlier, like elementary school, the decision might have been different. However, Yoder states that, as I mentioned, children can drop out at the age of 14.
What are the advantages and disadvantages of having an established religion?
Well, many of the founders believed religion, and particularly in small homogeneous towns, to foster good ethics and morality. And that can be incredibly important for a large society. However, establishing a religion also pushes someone's philosophy on someone else, and that's just generally not the moral thing to do.
And considering the diversity of the United States, it could be very dangerous for us to have an established religion. It would lead to significant discrimination against certain minorities.
And currently, the establishing of a religion would go against the Establishment Clause and the First Amendment, which gives the distinct way of life and freedom of religion.
Does the Hobby Lobby case get us closer to an established religion?
I don't think so. I mean, oh, is it okay if I finish? I don't think so. And that's, I mean, there are pros and cons to RFRA, as in like, it doesn't set necessarily precedent, but by granting injunctive relief to just a federal law, I don't think that qualifies as establishing religion, but we definitely disagree with the ruling.
Very well presented. Thank you very much. I appreciate all that you have discussed with us. I will give you some follow-up comments. Number one, I'm very impressed with the number of cases that you have at your command, because this is an area where the Supreme Court has weighed in heavily with regard to the rights of people, with regard to the rights of religious groups, and with regard to the function of government when it comes to the relationship between religious groups and the law. And I thought you had some very instructive comments. I was surprised that you knew about the Gary B. Snyder case, which followed up on the San Diego Independent School District versus Rodriguez, both of which basically said you cannot limit in-house gatherings for religious groups. It was interesting to listen to you talk about Plyler v. Doe and the inability to discriminate against illegal alien children. You did reference to the Colorado Constitution and the fact that it is somewhat confusing with regard to our continuing rights. And I thought the reference to Tinker was very, very interesting in terms of the ability of the students to express themselves with regard to at least the draft and so forth and so on. And whether or not they had a religious objection to serving in a war. I like your reference to Morse v. Frederick and the Kuhlmeyer case in particular, Abington School District, I like that as well. And your analysis, well, when it came down to vaccines, you came up with Jacobson v. Massachusetts, and I thought that was particularly pertinent. I like the fact that you balanced your comments between and among your panel. It seems like you all had some very strong opinions. You expressed them well, and you didn't necessarily agree with each other on everything, but there was a widespread agreement with regard to Yoder, which is the principal function of the question. Came up with Pierce versus Society of Sisters. I thought that was excellent. And all I can say is congratulations to you and your panel coaches. I'm going to turn the rest of the comments over to my fellow judges.
Yes, I agree with all of that. I was really impressed by your command of the subject matter. You all speak like lawyers, and talking to me about injunctive relief, and Jude, your disenchantment with the fact that all these laws are split and nobody's got a real consensus. That sounds like a lawyer talking. So it was a fun discussion. I was trying to bait you with both of my questions into giving me a little bit more of those opinions, because if you're gonna tell us that the panel is split, then that's the most interesting thing we hear. So be ready to bring that disagreement forward in your follow-ups. And play off of each other. I don't think I have a sense of where the panel is split and who thinks what. So if you're going to take that position, make sure that we can hear from both sides. But you did an excellent job in using the questions to show us what you know, which is of course the big goal. I would just love to stay and talk to you more and find out who's on what side of what. So congratulations. Thanks for preparing so well.
I really echo what the other judges have said. I had the same thought about the discussion that the panel was split, and then I was anticipating hearing a little bit more argument about what made some of you be supportive of Yoder and what made some of you not be supportive of it. We did hear a little bit of that in between, but I was really left kind of wanting to hear more. But you were the first group that mentioned that the quote misstates the Yoder decision. And I did like the comment that the state of the law is in a state of confusion. I thought that was very well put, but you really had, as others have said, you had a grasp of the cases at your fingertips and really brought a lot of that to us. And so I really appreciate that. Very well prepared, very well presented. Thank you and congratulations.